Today I'm going to explain Articles 1533 and 1534 of the Civil Code, particularly the law on sales. The remedies available to an unpaid seller. I'll keep the explanation simple, practical, and supported by examples. So, Article 1533 tells us that an unpaid seller may resell the goods if the buyer defaults. There are three situations where resale is allowed. First, when the goods are perishable. For instance, a seller delivers 100 kilos of fish, but the buyer refuses to pay. Since the goods will spoil, malata, the seller can immediately resell them to someone else. And the second is when the contract itself says that the seller may resell if the buyer does not pay. Another instance is let's say for example, a contract for laptops states that the seller may resell upon default. So the third, when the buyer has been in default or has default for an unreasonable time. This depends on the circumstances. If payment was, let's say for example, due on January 1 and the buyer has not paid for weeks or months, resale becomes justified. Once the seller resells the goods, he is no longer liable to the original buyer. He can keep any profit, and if he suffers a loss, he can recover damages. Yes, maybe. The new buyer also obtains good title, even if the original buyer complains. So what's important is the law says notice is not essential to the validity of resale. The seller should simply exercise reasonable care and judgment when reselling, whether through public auction or private sale. However, the seller cannot buy the goods himself, directly or indirectly. Let us proceed to Article 1534. Aside from a sale, an unpaid seller has another remedy: rescission of the transfer of title. This remedy applies in two situations. First, when the seller expressly reserved the right to rescind in case of default. For instance, a contract for the sale of a car states that the seller may rescind and take back the vehicle if the buyer fails to pay. Second, when the buyer has been in default for an unreasonable time. Just like in resale, what is unreasonable depends on the circumstances. But rescission is not automatic. The seller must show an intention to rescind, either by giving notice to the buyer or by performing an overt act such as retaking the goods or stopping their delivery. Communication of the notice is not required for validity, but whether the buyer was informed becomes relevant if there is a dispute about the length of the delay. Once rescission is properly done, the seller resumes ownership of the goods. He is no longer bound to deliver them and may claim damages caused by the buyer's breach. So to summarize, Article 1533 allows the unpaid seller to resell the goods. This applies when the goods are perishable, when resale is allowed by the contract, or when the buyer has delayed payment for an unreasonable time. And in contrast, Article 1534 allows the unpaid seller to rescind the transfer of ownership. This also requires either an express reservation in the contract or an unreasonable delay in payment. And it becomes effective once the seller manifests the intention to rescind. Both remedies free the seller from liability and give him the right to recover damages from the buyer. And that's the essence of Articles 1533 and Articles 1534. Thank you.
Article 1535 provides that subject to the provisions of this title, the unpaid seller's right of lien or stoppage in transitu is not affected by any sale or other disposition of the goods which the buyer may have made unless the seller has assented thereto. If, however, a negotiable document of title has been issued for goods, no seller's lien or right of stoppage in transitu shall defeat the right of any purchaser for value in good faith, to whom such document has been negotiated, whether such negotiation be prior or subsequent to the notification to the carrier or other bailee who issued such document of the seller's claim to a lien or right of stoppage in transitu. So this provision focuses on the effect of a buyer's subsequent sale of the goods and the distinction between goods covered and not covered by a negotiable document of title. So as a general rule, the unpaid seller's right of lien or stoppage in transitu remains even if the buyer has already sold or otherwise disposed of the goods. This means that the seller does not lose his right to hold the goods or to stop them while in transit just because the buyer resells them to someone else. However, this general rule has exceptions. First, when the seller has consented to the resale or disposition by the buyer. So if the seller agrees to the resale, he can no longer assert a lien or stoppage. And second, when the second buyer is a purchaser for value in good faith of a negotiable document of title. Here, the law protects the innocent purchaser who relies on the negotiable document. In such a case, the unpaid seller's lien is defeated. So the effect of the sale of goods that are still subject to the seller's lien or stoppage in transitu depends on whether the goods are covered or not covered by a negotiable document of title. So when the goods are not covered by a negotiable document of title, the seller can give no greater rights than he himself has. This means that the second buyer who purchased the goods from the original buyer acquires only whatever rights the original buyer had at the time of the sale. So if the original buyer had not yet paid and the unpaid seller still had a valid lien, then the second buyer takes the goods subject to the same lien. But when the goods are covered by a negotiable document of title, the rule is reversed. The seller's lien cannot prevail against a purchaser for value in good faith to whom the negotiable document has been endorsed. In other words, the negotiable document of title cuts off the unpaid seller's rights, protecting the bona fide purchaser who relied on the document. This aligns with the principle of negotiability, where the document itself carries the title and good faith purchasers relying on it are shielded. Article 1536 provides that the vendor is not bound to deliver the thing sold in case the vendee should lose the right to make use of the term as provided in Article 1198. So, the seller is not bound to deliver because the buyer has lost the benefit of the term. So, under Article 1198, the debtor shall lose every right to make use of the period under these circumstances. First, when, after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debts. Second, when he does not furnish to the creditor the guarantees which he has promised. Third, when by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. Fourth, when the debtor violates any undertaking in consideration of which the creditor agreed to the period. And fifth, when the debtor attempts to abscond. So, Example, A purchased goods from B. A promised to give certain securities, as a result of which A was given 1 year within which to pay. A failed to give the securities can be compelled to deliver. So answer is B cannot be compelled to deliver. Since A did not furnish the promised securities, the obligation becomes immediately due, and B may lawfully refuse delivery until A pays.
Good day, everyone. For this part of the report, I will focus on Articles 1537 and 1538 of the Civil Code. These provisions deal with the sale of real property and the obligations of the seller when the land sold has defects, burdens, or limitations. We will look at what the law requires from the seller, what the buyer is entitled to, and how the courts resolve disputes that involve these articles. I will first walk through the exact wording of each article, then explain their meaning. For this slide, we now look at Article 1537 of the Civil Code on the condition of the thing and the right to fruits. First, let me read the provision. The vendor is bound to deliver the thing sold and its accessions and accessories in the condition in which they were upon the perfection of the contract. All the fruits shall pertain to the vendee from the day on which the contract was perfected. So, what does this mean? For this slide, I divided Article 1537 into two parts, letter A and letter B. A. Obligation to deliver the thing and its condition. First, on the obligation to deliver. Article 1537 says that the vendor is bound to deliver the thing sold together with its accessions and accessories. So the seller does not only deliver the main object, but also everything that naturally or legally goes with it. Next, the property must be delivered in the same condition as when the contract was perfected. So, whatever the state of the thing at the moment the parties agreed on the sale, that is the condition the buyer is entitled to receive. The seller cannot downgrade or worsen the thing while waiting for delivery. To make this effective, the law obliges the vendor to preserve the thing pending delivery, applying the diligence required under Articles 1163 and 1164. So, from perfection up to actual delivery, the seller must take care of the property as a good father of a family, or according to the standard agreed by the parties. The last point here is that the accessory follows the principle. In obligations involving a determinate thing, delivery includes all its accessions and accessories. So, by analogy, when a credit or a property is assigned, the accessory rights and items go with it, unless there is a clear agreement to separate them. B. Right to fruits. Now, for letter B, the right to fruits. Under Article 1537, all the fruits generated by the thing sold shall pertain to the vendee. The key moment here is the perfection of the contract, not the physical delivery. So the vendee's right to the fruit starts from the day the contract is perfected. From that date onward, whatever fruits the thing produces already belong to the buyer. This rule is subject to stipulation, so the parties can agree otherwise. If the contract says that the seller keeps the fruits up to a certain date, that special agreement will prevail. As an example, if a goat is sold and before delivery, the goat gives birth, that offspring is already considered the fruit of the thing sold. Because the sale was already perfected, the offspring belongs to the buyer, even if the goat has not yet been physically delivered. So, in summary, Article 1537 protects the buyer in two ways. First, by requiring the seller to preserve and deliver the thing in the same condition with all its accessories, and second, by granting the buyer the fruits from the moment the sale is perfected. We now go to Article 1538, which deals with the risk of loss deterioration, or improvement of the thing sold. Let me read the provision. In case of loss, deterioration, or improvement of the thing before its delivery, the rules in Article 1189 shall be observed, the vendor being considered the debtor. So this article is quite short, but it is important. First, notice that it talks about what happens before delivery of the thing sold. The sale is already perfected, but the object has not yet been physically delivered to the buyer. Instead of listing a new set of rules, Article 1538 sends us to Article 1189. Article 1189 is the general rule on what happens to a determinate thing in an obligation to give when there is loss, deterioration, or improvement while a condition is pending. Here, the law says apply Article 1189 and treat the vendor as the debtor and the vendee as the creditor. So now I will explain how Article 1189 applies to a contract of sale through Article 1538. Here, we treat the vendor as the debtor and the vendee as the creditor. The table shows what happens to the obligation when the thing is lost, deteriorates, or improves before delivery. Let me go through each situation. First, loss without the fault of the vendor. For example, the thing is destroyed by a fortuitous event, like a fire caused by lightning. In this case, the obligation of the vendor to deliver is extinguished. The seller is no longer obliged to deliver because the thing no longer exists. However, the buyer still bears the loss, which usually means the buyer must still pay the price if there is no contrary agreement. Second, loss through the fault of the vendor. Here, the seller is negligent or acts in bad faith and the thing is lost. In this case, the vendor must pay damages to the buyer. So the risk and the financial burden shift to the seller because the loss is due to his fault. Third, deterioration without the fault of the vendor. The thing becomes worse, but not because of the seller's fault. For example, normal wear and tear or damage due to a natural event. Here, the buyer bears the impairment. The buyer must still accept the thing in that condition and has no right to damages. Fourth, deterioration through the fault of the vendor. Now, the seller is at fault, and the thing becomes worse in quality or value. In this case, the buyer has a choice. The buyer may choose rescission, meaning cancellation of the sale with damages, or the buyer may insist on fulfillment, that is, delivery of the thing in its worsened condition, also with damages. So the law gives the buyer an option, but in both options, the buyer can claim damages. Fifth, improvement by nature or by time. For example, land that increases in market value, or trees that grow and become more valuable. Here, the improvement benefits the buyer, even if delivery has not yet taken place. Any natural or time based increase in value inures to the vendee. Lastly, improvement at the expense of the vendor. The seller spends money to improve the thing after perfection but before delivery. For instance, he builds a fence or renovates part of a building. In this situation, the vendor has only the rights of a usufructuary. That means he cannot demand full reimbursement as a matter of right. He may be entitled only to limited rights, such as removing certain useful or luxurious improvements if this can be done without damage, or as provided by law on usufruct. So, to sum up, Article 1538 tells us to apply Article 1189. The allocation of risk depends on two things: whether the thing is lost, deteriorated, or improved, and whether the vendor is at fault or not. And now that ends my discussion for Article 1537 and 1538. I hope you learned something today. Thank you and have a wonderful day, everyone.
Good day, everyone. I will be discussing Articles 1539 and 1540 of the new Civil Code. So, Article 59 provides that the obligation to deliver the thing sold includes that of placing in the control of the vendee all that is mentioned in the contract in conformity with the following rules. First, if the sale of real estate should be made with a statement of its area at the rate of a certain price for a unit of measure or number. The vendor shall be obliged to deliver to the vendee if the latter should demand it. All that may have been stated in the contract. But should this be not possible, the vendee may choose between the proportional reduction of the price and the recession of the contract, provided that in the latter case, the lot in the area be not less than one tenth of that stated. So the same shall be done when even when the area is the same. If any part of the immovable is not of the quality specified in the contract. So the recession in this case shall only take place at the will of the vending when the inferior value of the thing sold exceeds one tenth of the price agreed upon. So nevertheless, if the vending would not have bought the movable had he known of its smaller area of inferior quality, he may rescind the sale. So paragraph 1 simply explains the delivering what was agreed. So the seller must give the buyer everything mentioned in the contract. Sample: Jerwin sold to Thomas a lot consisting of 1,000 square meters at the rate of 2,000 per square meter. So the actual area being delivered by Jerwin is only 880 square meters. So there is a deficiency of 120 square meters. So that 120 square meters is equivalent to 12%, which is more than one tenth. So since Thomas, the buyer, so he has the right to choose the options. First is he may rescind the sale because the deficiency is at least 10%, or ask for a proportional reduction of the price. So if Thomas, uh, Jerwin only deliver 880, so times 2,000, so Thomas should only be paying 1,760,000. But if Thomas already paid the price of 2 million, he has the right to demand for a refund amounting to 200,000 or 240,000 pesos. So second, if the land area is smaller than agreed. So if the contract specifies the land size and the price per unit, the buyer has two options. If the actual size is smaller, so the buyer can either ask for a reduction in price based on the missing area, or the buyer can cancel the contract, but only if the missing part is 10% or more of what was promised. So, example, a parcel of land described as first class residential land with an area of 300 square meter with estimated price of 10,000 per square meter. So the actual property delivered is 300, which is the agreed area. So, but 150 of the 300 square meter is swampy and cannot be built upon, making its quality inferior. So, an appraisal shows that because of this defect, the property's value decreased by 15% of the total price. So, since 15% more than initial ang threshold na 10%. So, the buyer now has the rights under Article 1539. So because the loss in value is more than 10%, so the buyer still may rescind the sale or demand a proportional reduction of the price based on the inferior value. So third, if the quality of the property is lower, so even if the area is correct, if any of the property is of lower quality than agreed, so the buyer can choose to cancel and the sale or ask for a price reduction. However, the buyer can only cancel if the lower quality reduces the property's value by more than 10%, of the agreed price. So number four, if the buyer wouldn't have bought it, so if the buyer wouldn't have purchased the property at all, had they known about the smaller size or lower quality, they can cancel the contract. So, ang number four, bisan pang dili moabot og 10% ni-reduce sa value sa property, pwede gihapon siya ma-cancel because of this paragraph, no? Na if the buyer wouldn't have purchased the property at all had they known about the smaller size or lower quality. So if even if the deficiency is less than 10%, recession is allowed. So if the buyer can prove he would not have bought the property had he known of the defect. So pwede gyapon ma-cancel bisag di pa maabot og 10%. So Maria bought a 300 square meter lot from Ramon for 3 million after he advertised it as perfect for commercial use. So after the sale, Maria learned that the property is actually a residential only, so and cannot be used for business. So the defect lowers the property value by 8%. So 8% wala siya maabot og 10, which is the threshold. So Maria has rights under article under the last paragraph of Article 1539. So the buyer may rescind the sale because he would not have purchased the property if he knew if she knew it could not be used commercially. Ma-cancel gyapon. So Article 1540 provides that if, in the case of the preceding article, there is greater area or number in the immovable than that stated in the contract, the vendor may accept the area included in the contract and reject the rest. So if he accepts the whole area, he must pay for the same at the contract rate. So, mo nga kung sobra ang area or number, so pwede ma-reject ma-reject sa buyer ang sobra. So this article deals with the opposite situation where the area or number of units is greater than what the contract says. So the buyer has options. So accepts only the area stated in the contract and refuse the excess, or accept the entire larger area. But so kung i-accept sa buyer, the buyer must pay for the excess at the same price per unit specified in the contract. Example, so Wellro buys a lot described in the contract as 400 square meter for 4,000 per square meter for a total of 1.6 million. After a survey, the land is found to be 450 square meter. So there is a excess of 50 square meter as stated in the contract. Under Article 1540, Wellrow may either accept only the 400 square meter he agreed to buy and reject the excess, or accept the entire 450 square meter and pay for additional 50 square meter at the same contract price. So pwede yapon ma-accept ang 450, basta bayaran lang same price, same contract price. So that's all for Article 1539 and 1540. Uh, mayong gabi o and God bless sa atong tanan.
Good day. I'll be reporting about Article 1541 to 1542. Article 1541 states that the provisions of the two preceding articles shall apply to judicial sales. This article deals with delivery of a real property or immovable property in a sale. This rule protects buyer making the transfer effective upon execution of a public instrument even without physical trading work. For example, A sells his lot to B in a notarized deed of absolute sale, even if B has not yet entered or begun using it. The law considers the sale delivered, and ownership transferred unless it says otherwise. Article 1.42. In the sales of real estate made for a lump sum and not at the rate of a certain sum for a unit of measure or number, there shall be no increase or decrease of the price, although there be a greater or lesser areas or number than that stated in the contract. The same rule shall be applied when two or more immovables are sold for a single price. But if, besides mentioning the boundaries, which is indispensable in every conveyance of real estate, its area or number should be designated in the contract, the vendor shall be bound to deliver all that is included within said boundaries, even when it exceeds the area or number specified in the contract and should not be able to do so, he shall suffer a reduction in the price in proportion to what is lacking in the area of work, unless the contract is rescinded because the vendee does not accede to the failure to deliver what has been stipulated. This article applies when real property is sold for a lump sum price, per certo, meaning the sale is for the property as a whole and not by the square meter. It is because in lump sum sales, the specific lot inside the boundaries is what is being sold, regardless of its exact. Hence, even if the actual area is bigger or smaller than what is written, the buyer gets whatever is within the boundaries.